Good day, everyone. I am your future attorney, Justin Marie Brillantes, and for today's session, we will be discussing about the legal practice. Indeed, topic law is a broad topic, so this will going to be a summary presentation about a certain subject in the law school, which is the introduction to law. So get ready, prepare your codals, and let us understand more about the law. A law is any rules of actions or norm of conduct applicable to all kinds of action and all object of creation. Therefore, it refers to whether it is a state law, a physical law, or a divine law. But according to the definition of Sanchez-Roman, laws are rules of conduct, just and obligatory, laid down by legitimate authority for common observance. Now let us discuss the world's legal system. There are a lot of legal systems present in the world. There are a lot of countries practicing different kind of legal system and adopting different legal systems. Now let us identify what kind of legal systems that our country, the Philippines, are practicing. First is the Roman law, which is a body of rules and principles adopted to guide the Romans in the conduct or observance of their personal and official affairs. It was first referred to as jus civilium as it was first dominated by strong ritualism and strong religious tenure. And then it was referred to later on as jus civil or as the law of the Romans. Second is the common law, which is derived from case laws and books of authority. It is founded on maxims, rules, and principles derived from time-honored usages which received acceptance from the courts of law. Lastly is the Mohammedan law, which is derived primarily from the Quran and from writings of Islamic jurisprudence. Now, these three legal systems have met and blended into one legal system observed here in the Philippines. Our new civil code is Roman in nature, and procedural laws are still observed, and our Mohammedan or the Mohammedan law is practiced here in the Philippines by our Muslim brothers and sisters, also known as the Sharia law or the law of the Muslims. Now let's talk about legal ethics and the code of professional responsibility. Legal ethics is the branch of moral science which treats the duties which an attorney owes to the court, to his clients, to his colleagues in the profession, and to the public as embodied in the Constitution and the rules of courts, and the Code of Professional Responsibility, the canons of professional ethics, jurisprudence, moral laws, and the special laws. The Code of Professional Responsibility is so interrelated with the legal ethics. As you can see, it is also a set of duties that lawyers have towards the society, the courts, the client, and the colleagues in the profession. Thus, before you could even aspire to become a lawyer, you should embody a sense of morality in you, and that you could practice and observe the legal ethics and the code of professional responsibility. Thus, there are also standards and requirements set before the admission to the bar. You could easily remember the requirements and the admission to the bar by easily remembering these abbreviations. The Karimboa. First is you should be a citizen of the Philippines, a Filipino, age of at least 21 years old, and a resident, of course, here in the Philippines. And your educational background, you should be a high school graduate, and in your college years, your course must be in relation to political science, logic, English, Spanish, history, and economics. Of course, you must have the moral characteristics, in which you should not have any present charges which involves moral turpitude. And of course, you must pass the bar examination, which has the passing rate of 75%. And with these subjects with their relative weight, first is the civil law, 15%, labor and social legislation, 10%, political and international law, 15%, taxation, 10%, remedial law, the heaviest, 20%, and the legal ethics and practical exercise, which is 5%. And if given a chance, you pass the bar examination, you must also take your oath before the Supreme Court and sign the attorney's roll and receive a certificate of the license to practice from the clerk of court from the Supreme Court themselves. Political law, on the other hand, is a branch of public law which deals with the organizations and the operations of the governmental organs of the state and also defines the relation of the state with the inhabitants of its territory. Constitutional law is a body of rules and maxims in accordance with which the powers of the sovereignty are habitually exercised. The constitutional law is the supreme law of the land. And I think most of us have already an idea that the government has three branches. First is the legislative branch, which is vested in the Congress, which is made up of senators and the House of Representatives. They are the ones who are making the law, also in participation of the people. Second is the executive branch, which is vested in the president, and its role is to enact laws. Lastly is the judicial branch, which is vested in the Supreme Court, and they are the ones who's applying the law and interpreting the law. Labor laws are the laws that governs the rights and obligations of employees and employers, providing as well for the rules by which such rights and obligations may be enforced. Social legislation, on the other hand, are laws that are designed to uplift the condition of workers or employees as members of the community and as human beings with recognized dignity. Labor standards law, lastly, is the law that states the minimum requirements prescribed by existing laws, rules, and regulations relating to wages. The minimum wages set in certain places, hours of works, whether you work 8 hours a day, 40 hours a week, and so on, the cost of living allowance, and other monetary and welfare benefits, including occupation, safety, and health standards. Civil law is defined as the mass of precepts which determines and regulates those relations of assistance, authority, and obedience existing among members of a family as well as among members of a society for the protection of private interests as defined by Santos Roman. Civil law is divided into four books or titles. First is the persons and family relations, which covers persons, personalities, marriage, and a family. Next is the property ownership and its modification, the modes of acquiring ownership, and lastly, the one that covers obligations and contracts. Taxation law is a process or means by which the sovereignty, through its lawmaking body, raises income to defray the necessary expenses by the government. So this is why in economics we are taught that the taxes are the lifeblood of a government, because without those, governmental projects, activities, and developmental programs will not push through. Income tax is a tax on yearly profits arising from property, professions, trade, or offices, or as a tax on a person's income, emolument, profits, and the likes. Income tax are direct taxes. Next is the commercial law. Commercial law is a branch of law which regulates the juridical relations arising from the commercial acts. So, commercial law involves the intellectual property code, the transportation code, the insurance code, security, pre-needs, business organizations, the sole proprietorship, the co-ownership and the partnership, and the banking law. Criminal law is that branch of public law which defines crimes, treats of their nature, and provides for their punishment. It has two books, and in the book one of the highlights are the circumstances which modify and alter criminal liability. First is the justifying circumstances, whereby the act is voluntary, but there is no malice because the actor acted in good faith, being compelled by some lawful act. Here, the burden of proof is transferred to the person who is accused of having committed a crime, and if he could invoke the justifying circumstance, then he would be free from both criminal and civil liability as if there's no crime committed. An example is a defense of a stranger, defense of a relative, and self-defense. Next is the exempting circumstances. Likewise, it has no malice because the act is not voluntary. Example of exempting circumstances is when a crime is committed by a teenager or a child. Next is the mitigating circumstances, which reduces the penalty to its minimum period or by degrees. An example of mitigating circumstances is when the criminal or the offender voluntarily surrenders to persons in authority, or he voluntarily confesses his guilt, and he is also a minor. Somehow it is put into consideration here. So Next is the aggravating circumstances, which increases the penalty if proven, as they indicate the unusual criminal perversity of the offender. So, an example of aggravating circumstances is abuse of confidence and advantages of a superior strength, committing the crime in or during nighttime, treachery, and the likes. Lastly is the alternative circumstances, which must be taken into consideration, which would either aggravate or mitigate the act done. So all of these circumstances are covered in the revised penal code from Article 11 to Article 15. Lastly, let's talk about remedial law. This law provides for the remedies and the procedures to be observed by way of enforcing rights and obligations. Now, I have mentioned this a while ago that remedial law comprises the heaviest weight in the bar examination, which is the 20%. Under the remedial law, it talks about rules of court, which is divided into 7 parts. First is the civil procedure, which treats of the enforcement and the protection of rights in civil cases. The other one is the provisional remedies, which are pre-judgment or pre-trial court orders to preserve the status quo until the court has issued its final judgment. It has 5 of its kind, and the following are in your screen. Next is the special civil action, which is an action whereby one party sues another to enforce or protect a right or to prevent the omission of a wrong by various special rules of procedures, and special civil action have 9 of its kind. There has 9 of its kind on your screen. The other rules of courts is the special proceedings. These are civil remedy taken to establish the status or right of the party to establish a particular fact. The other one is the criminal proceedings, which provides for the apprehension, prosecution, conviction, or the acquittal, as the case may be, of a person who is accused of having committed a crime. Next is the evidence, which means sanctions in the rules of ascertaining in judicial proceedings a truth respecting a matter of fact. It has different kinds of evidences, 8 of its kind. First is the documentary, the testamentary, real, circumstantial, corroborative, cumulative, the prima facie evidence, and lastly, the expert evidence. The last rules of court is the one which is the rules concerning the admission to the practice of law. And I believe we have somehow tackled this a while ago in our previous discussion.